Prosecutor Angela Corey says her record this year is an impressive 38-2. Those two losses, though, include George Zimmerman and the non-verdict against Michael Dunn in the killing of Jordan Davis. What was it like to be at the center of such high-profile cases? Were mistakes made? Is the problem the jury or the law itself? We sat down with Ms. Corey and asked her about it all, starting with what she thinks about George Zimmerman calling himself a victim.
There was one victim in that case, and that was Trayvon Martin. He was legally the victim, and he was factually the victim. So it's a little bit disconcerting to hear that anyone else would be laying claim to that title.
Supporters of him say, you see, he's a real gun owner. He knew his rights. He was in a dangerous situation, and he did what our Constitution allows. Is that how you see George Zimmerman?
Well, the way I see anyone who exercises their Second Amendment rights, myself included, is that with the great constitutional right to bear arms comes great responsibility. And I believe that that responsibility extends to knowing when to put yourself in a dangerous situation, when to draw your weapon, and when to just leave things alone and mind your own business.
Well, several of the notions that you just listed, you could tick off that George Zimmerman didn't follow those directives, and yet under the law in Florida, he still wound up having a compelling defense. How can that situation exist, though? I mean, isn't that just a patently obvious example that this law doesn't work, that it creates a confusing standard and a low bar that often rewards poor choices?
As prosecutors, we believe that the former justifiable use of deadly force covered the people it was intended to cover. It protected homeowners. It protected store owners. You don't even have to use a defense because it's deemed to be justifiable homicide right off the bat. Removing the duty to retreat in certain situations has really hurt prosecution cases. The defendant can say anything they want about threats that were made, and this is especially difficult in a one-on-one situation like we had with Trayvon Martin and George Zimmerman. No one knows what actually happened because you only had one person left to tell the story. In the Michael Dunn case, we had independent witnesses who told those jurors, we never heard a threat come from the car where those four young men were. Never did we hear anything from those four young men. Yet Michael Dunn could take the stand and say he heard several threats coming from the car.
It has to come down to the gun, right? Somebody, or three of them, or two of them, must have believed that Dunn did see a gun and that maybe the kids got rid of it. I mean, what else could it be?
What it could be is that our law says that the threat doesn't have to be actual, but that it has to be perceived. So it may not have come down to an actual gun or weapon in Jordan's hands at all. We won't know, and we'll go right back in and retry this case.
How scary is that, though? So I can imagine seeing a gun, you find no gun, I shoot up this whole car, and I wind up getting away with it. It's tough to swallow.
Well, you know, it's a little bit tantamount to the fact that, as you alluded to earlier, Chris, that Mr. Zimmerman sustained injuries in a fist fight that would never have allowed the police to arrest Trayvon Martin for anything other than a battery. That bloody picture told a story that didn't exist in the law. Getting two cuts on the back of your head is not great bodily harm. There was no broken nose, and he had two tiny cuts on the back of his head that needed no further treatment than Band-Aids. Self-defense is a tough law for us to overcome. It's an affirmative defense that we have a huge uphill battle overcoming, especially where there's injury to someone. We fought so hard for that conviction, put on a very hard-fought and good case, and the jury simply could not find him guilty beyond a reasonable doubt. Why would the prosecution ever take a hit for that?
Because people feel it's a pretty obvious situation, and that whether it was the law or how the case was argued, a man who killed somebody when he didn't need to is walking around free, and a young man is gone.
I understand that, Chris. I do understand their sentiment, and we were hurt by that as well. But what they have to understand is that had nothing to do with race. It has to do with the laws of justifiable use of deadly force. And we have young black men who have walked on not guilty verdicts from shooting and killing other persons, but nobody is ever outraged at those not guilty verdicts. Everybody focuses on race, and I wish they would stop doing that unless it truly is the issue in the case.
I respect that.
But I think that the facts and the law The facts and the law are what they are, and I would invite scrutiny into all of our cases on justifiable use of deadly force and not just 2 of them.
Do you have any concerns as a public official that your job is on the line with these types of cases and the Zimmerman not going the right way, Dunn not going the right way in many people's mind? Does it make you worry about your job?
Well, first of all, Dunn has gone the right way, and we're 4/5 of the way there with Michael Dunn. So for the people who want to continue to criticize me, they're going to do that no matter what we do. Mr. Dunn is looking at 90 years in Florida State Prison with 60 years of minimum mandatory. How anyone could be unhappy with these verdicts, knowing we intend to retry count 1, is beyond me, but we're going to keep going into the courtroom and fighting for justice for our victims without regard to what people are saying, even though what they're saying is completely uninformed and ill-informed.